1. Let's continue our special joint meeting, and please invite candidate for the position of the judge of the High Anti-Corruption Court, Yevlakh Oksana.
Yevlakh Oksana is invited to join the commission in the room. Please sit down.
Good afternoon,
Hi, Oksana. Please be seated. And
what
where
is the
should
correct
I
pronunciation of your surname? Please look at me.
It's me talking to you.
Yevlakh.
Yevlakh, is this correct?
Just like you made
The
it.
way you did it
Yevlakh.
was
Okay.
Correct. I don't even remember how I pronounced it.
We are considering the issue of compliance
So
of
the issue
candidates
of
for the
your
position of the
eligibility will be
Yevlakh
considered
Oksana Oleksiyivna, with
in
the
the
criteria set out by
session
Article 8 of the law
of
of Ukraine on the
the
High Anti-Corruption
commission.
Court. Two votes.
Я розумію. Будь ласка, щось з цією проблемою зробіть. А? Зараз як, пане, робите? It's okay?
No, I don't hear anything anymore. You hear something, John?
Is it okay? Is it now one voice?
Yes, one voice. Thanks.
Thank you very much. Так, в залі присутні члени громадської...
So we have present members of the PCAE, Robin Heinbrook-Heisen, chair of the PCAE, Norman Aas, Mary K. Butler, remotely, Gabriela Yotkaida-Granskiene, remotely, John J. O'Sullivan, and members of the HQCJ of Ukraine, Mikhailo Bogonis, Людмила Volkova, Vitaly Гацелюк, Yaroslav Duk, Roman Kadysuk, Oleg Koliush, Igor Kushnir, Ruslan Melnik, Ruslan Sabajdash, Ruslan Sidorovich, Sergei Chumak will join us in a couple of minutes, and Halina Shevchuk. Do you understand the composition of the HQCJ and PCAE? Yes. We are explaining your rights to you. You have the right to request recusal of members of the Commission provided there are grounds set out by the law to provide motions and explanations, express your opinions, objections regarding issues that are considered, and challenge decisions following the manner stipulated by the law. During the special joint meeting, we are not considering any new material submitted by the candidate if previously the candidate had an opportunity to submit such materials, but the candidate did not do that. If there are circumstances that can significantly impact decision-making upon the motion of the candidate or the initiative of at least 3 members of the HQCJ or PCAE, there might be adopted the decision on acceptance of additional documents, provided that at least 3 members of the PCAE have voted for this decision. Do you understand your rights? Do you have a recusal request? No. Also, I would like to point out that we have to comply with the requirements of the law. The rapporteur is Commission Member Volkova Lyudmila Vakolayevna. Please. The floor is yours. Thank you. With the decision of the ECGA dated June 3rd of 2025, there was announced competition for filling in 23 vacant positions of judges of the High Anti-Corruption Court and the Appellate Chamber of the High Anti-Corruption Court. By the specified deadline, the Commission received an application from Yevlakh Oksana Oleksiyivna on admission to participation in the announced competition for the vacant position of the judge of the High Anti-Corruption Court as the person compliant with requirements of paragraph 1 of part 2 of Article 7 of the law of Ukraine on the High Anti-Corruption Court and the conduct of qualification evaluation with respect to her to confirm her capacity to administer justice in the respective court. With the decision of the Commission dated September 18 of 2025, the candidate was admitted to the qualification evaluation and participation in the competition. With the decision of the Commission dated September 19 of 2025, there was appointed qualification evaluation for vacant position of judges of in the Hague and the Appellate Chamber of the Hague. On the September 19th, so there was appointed the qualification evaluation with the decision of the Commission dated February 4, 2026. General results were approved. Present results of the qualification exam, the candidate received 351.78 points as it was admitted to the second stage of the qualification evaluation, that is, examination of the dossier and conduct of the interview. In 2004, the candidate graduated from the National Academy of Internal Affairs of Ukraine and received a complete higher education under specialty legal scientist and obtained the lawyer's qualification. The candidate does not have academic degree and title. From 2001 to 2010, the candidate held positions of the legal counsel, chief specialist legal counsel, leading specialist. From 2010 to 2013, she engaged in attorney's activities. With the decree of the President of Ukraine dated November 7 of 2013, she was appointed to the position of the judge of Romansky City District Court of Sumy region for 5 years. With the decree of the President dated October 17 of 2019, she was appointed to the position of Romansky City District Court of Sumy region. The candidate had judicial experience of over 5 years. She is fluent in the state language at the level of the first degree. The candidate had submitted the declaration of family ties, integrity declaration, and declaration of the candidate for the position of the judge. During the conduct of the competition, the Commission sent requests to the SGA of Ukraine, Security Service, Office of the Prosecutor General, State Border Service of Ukraine, NSCP, National Police, NABU, Ministry of Justice of Ukraine, other public authorities, and we got responses. Besides, on February 16 of 2026, the Commission received an appeal from civil society organization ANTAC regarding the candidate for the position. That's it from my side. Thank you. Okay, Mr. Robert, over to you. And the PCAE members, please.
Thank you, Mr. Chair. I pass the floor to John O'Sullivan, who is the rapporteur in your file.
Good afternoon. Oksana, is that how you pronounce your name?
Yes.
We're going to go by first names today, okay? And I'd like to introduce you to the other members of the panel. Sitting next to me is Robert. He's a lawyer in the Netherlands, and he's the chairperson of the PCIE. Next to him is Norman, who is a lawyer from Estonia. And if you look up to the TVs there, on your left is Mary Butler, who is a prosecutor in the United States Department of Justice. And next to her is Judge Gabriel's Supreme Court judge in Lithuania. So I noticed that you've been a judge for a number of years, since 2013, in a city district court judgeship. Tell me, what about that or any other experience in your life has prepared you to become a hack judge?
I have worked as a judge for over 10 years now. While working as a judge, I considered the cases in the corruption sphere, among other cases. And that's why it was not 1, 2 cases. These were several cases, up to 10 cases. These were cases related to administrative offenses, related to corruption, like the failure to submit declaration. With respect to my experience before becoming a judge, I was the attorney. I had cases related to the sphere of corruption. I was not defending clients back then, but I was providing assistance in criminal proceedings a lot, and in civil proceedings. Before that, I worked in the sphere of justice in different areas, like from accidents, pension fund, and I was also the lawyer at an enterprise. So I have diverse experience, not narrow experience. And accordingly, when I was applying for this competition, I thought that I had sufficient experience in order to be useful in this particular court. I also have lots of life experience. I had I provided my explanations. There were some risky situations related to reputation risks. Indeed, I got my lessons learned, and I believe that I've made conclusions for myself based on that.
Okay, thank you. So I want to ask you some questions about your finance and also your disclosures in your declaration. I'm going to start out with a home that you received as a gift in July of 2022, a few years ago, from a fellow named Ihor, and I'll pronounce his name, Sherbina. Can you tell me who Ibor Sherbina is and why he gifted you a house and land plot?
I've provided that in my written explanations. Indeed, this fact happened. Ihor Sherbina is no one to me. He is no one to me. This form of the civil legal transaction was related to the fact that back then I was at the stage of divorce with my first husband, and he is serving in the armed forces of Ukraine. So he doesn't have an opportunity to come often. That was our mutual agreement. He submitted a claim to get divorced. That was the life situation that we had. And he suggested that he wanted to keep our joint house that we gained over the 26 years of our marriage, and he wanted to keep that in his own ownership. And instead, he suggested for me to choose housing in the city of Romny. Back then, we had housing in the rural area. We bought it together with my husband previously in 2015. And it was registered in the daughter's name. I've also been providing explanations about that. That is the house that was habitable, but it's more like a cottage house. We insulated it a bit, and I was living there in the hope that after all I will be transferred.
Because I have a lot of questions, so if you could just try to focus in on my question, which is, did you know him, and why did he give you this house? Did you know Mr. Sherbina, and why did he give you this house?
No, I did not know Mr. Sherbina before the conclusion of the deed of gift. That house was, my husband suggested to select this house. I found it through the ad at the website. It was unfinished construction, and I informed that in exchange of the house in Nizhin, I would agree for this house. I did not know Sherbina, and since marriage was not dissolved yet back then, and that house would have been joint shared ownership of the married couple during the sale. That's why the husband offered that he would pay for this house to Sherbina, but the deed of gift would be registered in my name. And that was the only purpose why we concluded this particular legal transaction. I know how it can be perceived and that it could cause respective questions, but I did not know Sherbina before this deed of gift was concluded. He was not related to us in any way. I had not seen him before then.
So Sherbina purchased the house in 2021, but didn't give it to you or gift it to you until 2022. Is that correct?
Yes, yes.
And did he originally buy the house for himself, or was the purchase always made with the thought that it would eventually be given to you?
When we were at the notary's office, I talked to him and I provided his explanation so that he would confirm, and he gave his phone number as well. He was buying this house to live there. As far as I know, his children live in Romny. his daughter got married there, and he wanted to move there. So as he was explaining, he wanted to finish that construction. So that was the house without any internal works. It was just like a brick box and windows. But it happened that the full-scale invasion started. That's Sumy region. We were partially until the end of March. We were in occupation, but as such, occupation was consistent in the fact that we were just blocked from both sides by the army. And nothing serious was happening on the territory apart from transit of military equipment and vehicles. And that's why he decided to sell that house.
So why did your husband not purchase the house and then provide it to you as a gift instead of having Mr. Sherbina provide it as a gift to you?
My first husband is a soldier. Soldier back then in 2000.
He was a soldier at the time that he paid for the house.
Yes, he is serving in the armed forces started from March 15 of 2022. And back then, he was transferred to the attack unit. And it was impossible to come often.
Have you provided any proof of the money that your husband gave to Mr. Sherbina for the home?
Apart from his personal explanations, I did not have, and the explanations of Sherbina that I provided to my written answers, no, I do not have any other documents apart from that.
And are you aware that generally judges are not allowed to accept gifts from third parties that exceed the legal limit, which at that time was about 2,600 Ukraine currency?
Yes, I know about that. And accordingly, back then, I looked through the case law of the Courts of Appeal, and that was related exclusively to the fact that the gift was related to the position. I did not see the corpus delicti of the offense in this regard, because the gift was not gifted to me as a judge. That was given to me as a citizen. The person given the gift did not have any interest in the judiciary and in court decisions. He has never been in our court, and as far as I know, he has never been in courts or his relatives. And that's why there was no interest in my particular work as a judge. And that gift had no relation to my work as the judge. And that's not the only decision of the Courts of Appeal regarding administrative responsibility for such actions. And I did not see the corpus delicti of this offense here. At the same time, I admit that I did not have a strict approach to how it will be perceived by the society from the outside, whether it would not cause reputational risks. Nowadays, I would say that if I were in this situation now, then I would have acted differently. I've have my lessons learned from this situation, and now my approach to issues related to life decisions is exclusively with the approach that how it will be perceived from the outside, given that I'm a judge, and whether it would pass the reputational and public check if necessary.
So it's your understanding of the law, you're telling me that a judge can receive a gift of any amount of money as long as they don't believe it's related to their official duties?
Well, yes. If a judge, exclusively for me, I saw that situation from the perspective of perception, not from the perspective of, it was not a gift in the civil legal meaning, in the ordinary meaning. And if we are talking about the definition from the law of Ukraine on corruption prevention, then of course, yes, that is a gift. But that was a civil legal transaction in the form of the deed of gift, not as a gift to me for some personal preferences or affiliation. And that's why I thought that there was no corpus delicti of the offense in my actions. As of today, given that indeed that looks for external observers at least difficult and strange for comprehension, then I think that a judge should not act in such a way.
So your divorce was final on September 1st, 2022, correct? And
Yes.
16 days later, on September 17th of 2022, you gifted this land to your aunt. Is that correct?
Yes. And the house and the land plot.
Yeah, I'm sorry, the entire thing, yes. Why did you decide to, well, just to get a little further ahead, your aunt then returned the property to you several months later. Is that correct?
In a year. Almost a year. Less than a year. In 11 months.
10 months, I think. July 18th. From September 17th to July 18th. Why did you give this to your aunt, and why did the aunt give it back to you?
The gift from me to my aunt was caused exclusively by the fact that we did not find a mutual agreement with the husband of how to divide the property. At first, we had one arrangement, but then if you look, mostly my husband had all the accumulated funds and accordingly what was earned throughout the lifetime, and if he really had the larger share of the contribution to the family budget because he was engaged in entrepreneurial activities, and that was the main source of income. His work was the main source of our family income. But when we were talking about dividing the property, there was an argument regarding the funds that he had at his accounts, that he was earning while working abroad, as to what should be left to children from that. And since he already had another family, we could not reach agreement. And there was a conflict during which he expressed that this house would be challenged by him. And that's why, in order to preserve this house, I gifted it to my aunt. She did not need it. That was not a gift for her entire lifetime. That was purely was as I described.
To put it out of the reach of your husband, or to put it out of the reach of the court that was deciding the land distribution or the property distribution?
So that he would not have access to that house, and so that he would not try to get it.
Okay, so I want to move on to the second topic. You have a son, I believe, who, at least in 2024, resided in Poland. Is he still in Poland?
Yes. On March 15th, 2022. So my first husband took him to the border. His father took him to the border. And he got conscripted. The father got conscripted without returning in the western of Ukraine. My son went to school in Nizhyn, and there hostilities were even more intense than in Sumy Oblast. And he lived in Germany until 2023, and then he finished school, and then entered the university in Radom, Poland. And he's still there.
And who supports him while he's been in Germany and in Poland?
In Germany, so he lived at my daughter's place. She is married to a German citizen, and he lived at her place because my son crossed the border himself without adults. She met him at that side of the border, and she submitted documents for parental care, or just care, and because he couldn't stay there on his own as a refugee. But such situations happened when minors crossed the border themselves and found themselves in Poland. So it was possible back then, and only care could be as a status for her. So that's how he made it to her family.
Then who paid for his support while he was in Germany and Poland?
As he lived in Germany, I would transfer money to him to his bank account. He had a bank account in hryvnia. My daughter spent the money she had received from us earlier, and my husband also transferred some money to him, not that much. The bigger amount of support was given by father, that is my daughter's husband. So everyone actually supported him and welcomed him to their family, and this is where he stays until now. They have good relationship.
And approximately how much were you sending him a year in US dollars?
Monthly, I send him 7,000 hryvnia. This is the need he has for clothes. 7,000 hryvnia per month to his card, his bank account. Some money I gave to him in cash when I visited him in 2023 and 2024. In February, I went to Germany to see him when he was still a minor. So I had an opportunity to go to Germany to see him there. Now I cannot do this, so I only transfer money to him in hryvnia. And since 2023, he has studied at university. He's a third grade student. He lives in a dormitory, and this is a state university. He doesn't pay for the dormitory. He doesn't pay for his tutorship, and he also gets a stipend from the university for good learning results. And he doesn't get any social benefit there apart from the stipend because he doesn't have a refugee status. He has a Pasal Ukur status, the word in German, but he did not receive any social benefit because of it.
And in August of 2023, your son entered Ukraine from Poland for several hours and then returned back to Poland. all within a few hours. Do you know the purpose of that trip?
Yes, I know the purpose of this trip. So the thing is, the law functions the following way. When he crossed the border for the first time and got registered in Germany, he was believed to be a refugee in Germany. But later, laws changed and he couldn't move from one country to another country and get a refugee status, someone fleeing the war. So after he did his exams and he got a possibility to attend university for free there, as funded by the state budget, the administration raised an issue, administration of the university raised an issue that he, as a Ukrainian residing in Germany, cannot study for free at university. And the university administration advised us to cross the border with Poland and with Ukraine in order to get his crossing registered. But before, as a refugee, he was granted the right to go to university for free. He was granted a dormitory, but no social benefit.
In 2024, you stated he was studying in Poland, but you didn't indicate his actual residence in your declaration. Why did you not indicate his residence?
Well, it's Radom. It seems like I indicated it in my declaration. I may have missed it by mistake, but I made it a point to indicate it. He was registered in Nizhyn. I may have stated his place of registration, not the place of residence, because he's not registered with the dormitory. I don't even know the address.
Let's move on to a house that you purchased for your daughter in 2015 in Yevlakh. You familiar with that?
Село Овлащі Роменського району.
Ovlashi village.
Yeah. And your daughter was
Yevlakh.
17? Your daughter was 17 at that time?
Так.
Yes.
And you purchased the house for approximately 60,000 hryvnia or 2,800 US dollars. Is that correct?
Так.
Yes, it is
And,
correct.
Why did you not declare its value in your declaration for 2015 to 17? You stated it was unknown.
Я задекларувала
I declared
рік придбання в подальшому.
the value as per the year of purchase.
Перше йде коли заповнюєш декларацію, то
And when you declare it for the first time, you indicate the value at the moment of purchase. So I interpreted it this way. So I bought it that year and I indicate the value for that year. And no purchase occurred in the following year of declaration. But after I talked to my colleagues, after I've read some explanations, I corrected this mistake and indicated the value in the declaration. So it was my fault of misinterpreting the declaration. It was not an act of concealing the amount on my part. So I just indicated it for the year. There was also a lot of talk of the fact whether the last evaluated amount should be indicated, or the previous one. So it was a fault of mine.
Okay. And you lived in that house, correct?
Так, я проживала в тому
Yes,
будинку.
I did. I lived in that house during all the work days, and for the weekend I went to Nizhyn because I also had home there and part of my family lived there. And when I came to work to Romny in 2013, my son was rather small. He only he was a pupil still. And then in less than a year, I took my son to Romny because my husband went to work abroad.
Why did you put the house in your daughter's name if you were going to live there?
Ну, таке було спільне наше рішення, що
Well, it was our common decision that we buy a house for my daughter so that she has her own house, and that was a village house, and it was mainly intended for seasonal use because it required much investment into repairs. So we used it seasonally, and we partially insulated it to make it livable. And we believe that it will be a house for seasonal use for my daughter. It's in the village, there is a garden, there is land for a kitchen garden, but circumstances turned out to be different. My daughter stayed abroad and married a German, and she did not return to Ukraine.
In 2014, you bought a Toyota of Avensis for approximately 47,000 hryvnia or 3,100 US dollars. Is that correct?
Так.
Yes, this is correct.
And you also didn't declare the value of that vehicle on your 2015, 16, and 17 declarations?
Таке ж саме трактування. Я в рік
So the same mistake. When I bought the car, we still had paper declarations, and I indicated the value in my paper declarations, and that was in line with the value indicated in the car trader shop. And then when we switched to digital reporting, digital declarations, I realized that I'm not buying anything as per the year of declaring, filling out the declaration. And that value is indicated in the paper declarations as of that year, and we did not carry out any evaluation, so nothing has changed since the primary act of declaring the value, and therefore nothing should be included. And only in 2021, NAZK, Anti-Corruption Agency, provided some instructions on that.
So you paid $3,100 for that car 11 years ago. Today, that car is advertised for between $4,000 and $6,000, which indicates to me that the $3,100 that you contend you paid is very low. Why is it that you were able to get this car at such a bargain price?
Ну, я не зовсім зрозуміла ваше питання, що значить зараз 6 тисяч.
I didn't understand. How come is it $6,000 now? It was a car in a state of emergency. I mean, was in dire need for repairs, and the price was like that. And now it costs around $3,000. So in 2014, the price indicated in declaration is in line with the real price, and as civil society wrote that the price is lower than in the real life, I disagree, but I saw such a claim. I didn't. I did state the real price.
You own a quarter share of a house and land plot in, I don't know how to pronounce this, Nizhyn, is it? Nizhyn? And you transferred that in 2015.
Ні.
But you indicated on your 2016 declaration that you transferred it or you terminated ownership of it in 2016. Why did you report it in 2016?
Це будинок, частина будинку.
So we're talking about a part of a house.
Знаходиться в частині,
It is located.
якій, можливо, було його використане, не те, що використане, можна було збудувати під офіс. Тоді я його коли
So that part of the house could be reshaped into an office. I was an attorney back then, and together with the individual that was a realtor, I gifted her that part of the house. We decided to eliminate that building because it was really dilapidated and it was not appropriate for use. And when I was appointed a judge, I lost my interest towards this building, and that building was bought for my name, and I decided to gift that part of the house and land parcel to my partner, that woman, the realtor. And in my 2015 declaration, so the agreement we concluded in November 2015, in more than 130 days is the deadline for someone to transfer the property, and I excluded it from my property and declared it in 2016.
You had another land plot in the same village or town that you purchased, or you indicate that you purchased for 15,000 hryvnia, or approximately 543 US dollars. At the time, it was valued at 49,000 or almost 50,000 hryvnia, which would be $1,836. Why was the price of the land so much lower that you paid than the valuation, than the official valuation?
That
land plot was proposed to me by the realtor that I mentioned. So she got a request considering this land plot. And those land plots could be privatized to construct housing. But she explained to me that people were not meaning to construct anything there. The official assessment was, as you said, around 50,000 hryvnia, but no one was ready to pay for this building, for that landlord, this amount. There is the Oster River nearby, and in spring, that land plot is impacted by the river. And some drainage work to be done to make it more appropriate. So that value was agreed with the customer, and the customer was ready to pay that value. So I don't know who actually asked for this value, or whether it was a compromise, but that was the value.
And again, in your declarations for 2019 through 2024, you indicated the value was not applicable, although you knew what the actual value of the property was, correct?
Yes, correct. So all those mistakes regarding the value that I didn't indicate in other following years after the purchase just were grounded by my misunderstanding of the rules of filling out the declares. So I bought a piece of property, I declared it the year of the purchase, and then I did not indicate the value further. But I made it a point to declare it immediately, and the value did not change. And just like with car or other property, I did not believe that I needed to really indicate the value. This is why I ticked non-applicable.
In 2018, your husband purchased a Mazda 626. You've indicated for 8,000 hryvnia, and you've never indicated the disposal of that property.
So I mentioned that he has this property. He arrived using this car from abroad, and the car had Polish plates. He said that he had bought it in order to make his trips, actually for work, because sometimes he needed an additional vehicle to have space for individual belongings. And that car was not registered in Ukraine, never, and it was not subjected to customs. And I haven't seen any Polish documents. And in 2018, I submitted a copy of just one document. Then this car was subjected to consular check, and he couldn't use the car for more than 2 months on the territory of Ukraine. And he exited Ukraine using this car, and he never returned. He said that he had just abandoned this car. He gave it away for shredding because it was really old. Produced in 1990s, was not really a very good car.
You indicated in your response to our questions 4 occasions where you felt there were attempts to informally influence your judicial decisions. Do you recall that?
Можна, якщо можна вточніть, що значить прес, тиск?
I don't hear the
як тиск, ніякого тиску не було на
Pressing.
мене стосовно прийняття юридичних
I
рішень.
have not encountered any
Можливо, я не
pressure
зовсім зрозуміла питання,
in
такого і не було.
legal decisions that I could take. I didn't provide such an answer. Maybe you're talking about
Було там питання
the question about
що я мала на увазі в анкеті, говорячи про якщо
in the questionnaire.
особи натякають на якісь рішення, це
So when
можливо це
someone is hinting or trying to
уточніть питання, не розумію.
suggest me a decision, but I haven't encountered any pressure whatsoever.
Well, you indicated I always perceive such statements as attempts at informal influence. However, none of them influenced my judicial decision. And then you gave 4 examples. You call that?
Так, це
Yes,
питання,
I do.
я правильно вас зрозуміла. В мене було питання у переліку від ГРМЕ, що я мала на увазі.
So I had a question from the public council. What did I mean when I said that when colleagues or officials suggest me some decisions and I put it in captions, the word suggest. And when I was asked the clarifying question, if I could provide examples, I provided an answer to that. And I explained it that it could happen in informal setting. Probably I should not go into detail because I quoted the number of cases there, and those conversations in informal setting happened with public figures, with officials, and also it happened during some discussions with colleagues. When someone says, I would have acted like this, I would have done that. So it wasn't pressure. It was the background against which my decisions were considered and discussed. My town is a small one.
Did you report any of them to the High Council of Justice?
Я не передавала про це, оскільки це не було втручанням. Я не розцінювала це як втручання.
No, because I didn't see it as interference. And during my activities as an attorney and as a judge, such discussions and advice, I didn't take it openly, but I don't take it as pressure.
Відповідно, я не повідомляла. Це не було прямим тиском чи якимсь...
So I did not report that.
Це не було таким, якщо ви про це...
Thank you. My time is expired.
Thank you, John. Mary and Gabrielle, you have a question for the candidate? No? Back to you, Mr. Chair.
Дякую.
Thank you. Madam Людмила, the floor is yours then. With respect to those questions that are raised by the UNTAC Center that the Commission received, partially they have been covered, but some of them have not been discussed yet. Yes. I have not asked the question yet. My first question is the following. You've already provided information, but please provide additional explanations regarding the residential house in the village of Ohlashi. The question is about the legal grounds based on which you registered that house in the name of your minor daughter. Did you use it? And if yes, why didn't you declare that? That house was registered under the sale and purchase agreement. The signatory was my daughter, but my husband and I granted consent to that. And there was a decision of the care body that registration in the name of the minor daughter would not violate any of her rights. Madam Oksana, I'm sorry, but I'm encouraging you to listen attentively to questions. My question was based on which grounds you decided to register that in the name of your minor daughter. Why? And if you used it, why didn't you declare that? I was explaining, and I will repeat that we wanted to have it as a cottage house for the daughter. Back then, that was 2015, we were planning that after all, she would live there. And then understanding that there would be no transferred for many years and that we would have to accordingly live in Romny. And then we planned that this house would be a cottage house, while the house in Nizhyn would be accordingly sold with time, and that we would live in Romny on a permanent basis. But it happened differently. So in not to get any additional operations, we bought it immediately in the name of the daughter. I live there. Yes, I lived there on working days. Why didn't you declare the right to use it? That was a paper declaration, and I was showing in section 1 the address of my place of residence, and I was pointing out that this house is owned by a family member. Some explanations about me having the right to use. I live there as a family member. I did not register any agreements starting from 2015. Did you live there? Yes. Well, after it was 2015, there was e-declarations. And there were explanations of the NACP regarding the use of real estate objects, even just under the right of permanent residence. 2015, 2016. Yes, but we were one family. We lived there as one family. She was a family member. She was specified in the list of family members. The question is why you didn't declare your right of use. I thought that I was declaring the address and the daughter in the list of family members and the ownership of this property to a family member, and I thought that it would be enough for me to use it. Some determination of the specific right, there was no rent agreement. That's accordingly the person who is a family member, then I have the right to use owned by a family member. Okay, understood. Thank you. My next question is about income received by a husband and a sudden increase. A civil society organization is asking about the specific type of your husband's activities. That is the period of from 2015 to 2021, and where was the abrupt increase up to 4 million per year in 2020-2021? I've provided explanations to the questions of the PCIe and documents. He was an entrepreneur. He engaged in entrepreneurial activities. And with respect to this information, his income was declared. In which declaration? In his tax declaration? Yes, in his tax declaration. And taxes were paid from it? Yes, taxes were paid from his income. With respect to 4 million, he sent that declaration from his account. I've attached it. I will repeat my question again. Please be more attentive. What type of activity? What resulted in a sudden increase? Did he change the type of activity? No. The type of activity did not change. He was still engaged in large-scale sale of construction materials and salt, and he was selling that wholesale as well. And accordingly, that was not a retail sale, that was not a store, like when people are selling bags of salt. It was among businesses. So the increase of the sale price resulted in the increase of turnover funds. And accordingly, that was the reason for the sudden increase. That was not his profit, that was his income. income, profit, or turnover funds. In the declaration, we see accordingly when the person is under the unified tax, then all the funds which he receives from the sale should be specified there. That includes expenses on the purchase subject as well. So if you look at the declaration as to the Romanian funds, that is 1,200,000. That is the funds that he had left, that he received from entrepreneurial activities as his own funds. Okay, understood. Thank you. My next question is that civil society organization is raising the question as to when you sold VAS manufactured in 2007, and if you sold it in 2019, why didn't you declare? Why did you declare it for 2019? The sale happened at the end of the year of 2018. I provided confirmation for that. And accordingly, the transaction was received, was declared that I got income from the sale of this car from a specific person. But I declared the car as my ownership in view of having it almost for a year in my ownership. And that's why I declared it as my ownership. And then I removed it from my right of ownership next year. Okay, thank you. Also, there is a question about the termination of the use possession of real estate property in 2016. Tell us, what is that transaction? That is the house that I was just explaining to the PCAE, the one that under the deed of gift was gifted by me to the real estate agent. Look, in your declaration for 2016, you did not have any changes in the real estate objects, but the very transaction is reflected that there was some legal transaction. It's not clear from the declaration. The legal transaction took place in 2015, and it was declared in 2015. In 2015, in the list of property, I kept part of this house with a land plot because I was using them until November of 2015. In 2016, I removed it from the object on the right of ownership, but there was no legal transaction in 2016 regarding the sale of property. Okay, understood. What gifts did you have in 2019, in 2022, 2023, we understand, but you also had the same gift on inheritance according to the data of tax inspection for 2012. Yes? Either inheritance or gift. That's how it's reflected. I did not get anything in 2012 in the form of gifts at all. Maybe inheritance? I was registering the inheritance of my parents. The inheritance of my parents was registered by me, I think, in 2003. And I sold that house to the brother and his wife. But I did not get any gift or inheritance in 2012. Okay, thank you. My next question is, we've already discussed the loan that allegedly your daughter gave to you. She gave it to you, yes? Yes. What were the needs for which you received two loans from the daughter while you were giving a loan to her at the same time? I got the loan from my daughter and from my ex-husband. I declared it. The loan from the ex-husband, now look, the loan was in 2022. You got the on the 1st of August, and then again on the 26th of August. Yes, I provided explanations regarding that. The first one was from my daughter, but that was like a sort of the first amount that I got from her. I got these funds to my currency account. What was the purpose? To repair the house. that was gifted to me. That was the house without any internal works. I'm not asking that. Tell us, please. You've also gave a loan to your daughter in 2021. Yes, in 2021, I explained the situation back then. My daughter wanted to buy a new car. They did not have enough money for that. We were accumulating money together with my ex-husband for the tuition of my son because he was supposed to finish school in 2023. And these funds were saved. I showed that we had these funds as savings, and I shared that money with her so that when necessary in 2023, she could repay them. She used then when the husband was mobilized, accordingly, they bought protection means, they bought a lot. Look, in 2021, you gave a loan. Was it repaid until August of 2022? No. It was used. It was used in April of 2022, partially, for the purchase of PPE for ex-husband, and accordingly she used this money for the residence of son. Okay. Also, we have questions about your declarations for 2022-2023. Did you have open bank accounts in Ukraine or abroad? And if yes, why didn't you declare that? I had the accounts. They are reflected in the declaration in respective lines, but I also included the current account of my son. And these are the accounts opened on the territory of Ukraine. But in the last column is the question of whom this account concerns. And by mistake, I mentioned my son in all the accounts, but two of those accounts are my accounts. I provided their numbers, account, but you didn't declare that these were your accounts by mistake, because I specified my son as the first one, and then I was declaring mine. I don't know, maybe it's popping up who owns it, and that's why accordingly it happened like that. It was a mistake. I had opened account and I still have these two accounts. We see only what you are declaring. My next question is about vehicle Ford Escape S of 2020, which you acquired into ownership. The question is whether your declared value for this vehicle corresponded to the real price. What was the purpose? Why there are discrepancies between this price and the price specified by the service center? There can be no difference. I've provided the certificate regarding that. It was 184,000 in the service center, and accordingly, I declared the same value. That car was bought at an auction abroad in technically malfunctioned condition, and it was officially imported through all the procedures of auction from the US. Did you provide information about its technical condition? I provided all the documents that I had during the purchase. There are declarations, and accordingly, the auction documents were provided about the condition of this car. If you go to the website of the respective auction, then based on the VIN code, you can even see pictures of that car. Okay, thank you. With respect to LLC Mirage Plus, you are the co-owner or you were the co-owner? Can you please explain why this LLC is not paying taxes? Now your husband is the owner of it? No, he is not the owner. That's an enterprise. That LLC was created in 2003. We were two co-founders, my husband and I. since for the establishment of an LLC, it's necessary to have several co-founders. That's why my husband suggested to me to register the private, because private enterprise could be registered in one name, but LLC has to have several co-founders. So I was a co-founder, but he was the only director who was managing that enterprise. The company worked quite well until 2007. And in 2007, accordingly, because of that commitments of contractors which worked with the LLC, there was accumulated debt that could not be repaid through the available funds of the company. That was 8,000 of tax from VAT. The prosecutor filed a claim on collection of these funds, and then the bankruptcy case was initiated because there was no property that could be collected to repay this indebtedness or any funds that could be collected. Enterprises that, according to accounting, were specified as debtors, they also bankrupted and they were liquidated. That's why that LLC was liquidated in 2007 and was removed from the register. Oh, thank you. Tell me, please. Please clarify your membership in different political parties. Since in some documents and applications, you are mentioning only your membership in the party Our Ukraine, but in some other documents, you are also mentioning your membership in the Party of Regions party. Please explain what happened. And secondly, how did you exit these parties? I was a member of Party Our Ukraine until 2010. In 2010, through submission of an application, I exited that party. I had a party ticket. Accordingly, I was engaged in active political activities. I was selected to the local council under the list of this political party. I took part in meetings of this party. It's clear what happened next. Then I was not in any party. And then, accordingly, I was, if we are talking about Our Ukraine party, I was in the central party, but in the Party of Regions, that was a local organization. I did not have a political party ticket. Did you enter the Party of Regions as a member of the party? It does not mean, it's like you were a member. Yes, yes, yes. Since when? From September of 2010, I addressed regarding that in order to get that official about the period of my membership, but they did not find that information. The only thing that I found is my application on exit. When did you submit your application on exit from the party? On November 7 of 2013, when I was appointed as a judge. Then I submitted an application on exiting the political party and on termination of my membership in the party. Why? In your applications to the commission, you said that you were a member of Our Ukraine party and you did not mention your membership in the Party of Regions. Due to the consideration that I was in the local organization of the Party of Regions and not in the central party. I was not at meetings of the Party of Regions, well, and you were at meetings of Our Ukraine party. And what about the association of the bar? Are you taking their active part? No. Then why didn't you declare the bar association, but you didn't mention membership? There was the respective explanation. The bar association at the initial stage was not mentioned. No, the question is that if you're not taking an active part in this organization, then accordingly...
So if you don't take active participation in that organization, you shouldn't have mentioned it. Well, the logic behind it is a bit different. The National Bar Association was indicated by me only by... I mean, why didn't you mention Nasha Ukraina? Because I didn't believe that I was a member of that party. I only was part of the city organization, city chain. Why were you interested in a commercial case around Komyshansky enterprise? I don't remember, but it was related to the details of the case. It was a commercial case, yes. But how did it relate to your judge's activities? I may remind you, it's fresh, 2025-2026. It was considered in Poltava and Kharkiv Court of Appeals, commercial court. I don't remember why I turned to this case. It's fresh. It was almost yesterday, 2025-2026. Yep, but it may have been related to the fact that someone indicated that they were working there, and I checked some data. Look, so we checked, you checked the decisions of the first court of first instance, then the decision of the Court of Appeals, and that happened throughout the time the case has been considered, was considered in 2025-2026. It was about delivery agreements, and your husband is involved in delivery, and it was about some sort of delivery. Well, it is unrelated. Even though my husband is an entrepreneur, but he does it part-time. But why were you interested in this case? So the only explanation that I can give you is that it was either something about the questionnaire. I don't remember. I don't have any more questions, colleagues. Do you have any other questions? If no, then Oksana, you have 1 minute to mention something you have not yet mentioned. So everything that I was asked about has been explained by me in writing. Thank you to the members of the Commission for an acute interest towards life circumstances, my life circumstances. Thank you for your questions. I ask you not to take my actions as an intended purposeful violation of law. I have made mistakes, lessons are learned, and in the future, I will be as rigorous as possible when taking decisions both in my personal and professional life. Thank you so much for participating in the interview. The interview is complete. Thank you.